Hearsay evidence in terms of admissibility in a criminal trial. Can you tell us what its value is or what its place is in a criminal trial?
For hearsay evidence, I think if my understanding is that it's not direct. First of all, it is an evidence that you've had. You're not even too sure whether what you've had is right or wrong. So when you're talking about its place in a criminal trial, for me, I think it will not have any probative value, because it is something you had. You've not seen it. You don't have direct interaction with that evidence.
No, but supposing it is you who had, why are you saying you don't have direct interaction?
Oh, sorry, I was talking now in the instance of a third party. Sorry. Okay. Sorry, yes.
So, okay. So what are you saying about it, that it doesn't have probative value?
Maybe I can qualify it by saying if it's by a third party, somebody reports to me that I had, yes, that it might be 50-50. I may not look at the probative value would be a bit lower. But if it was, I directly had it, and if it was in an environment.
So if you are conducting a trial, you
yes,
are conducting a murder trial, and a witness testifies, and he or she gives hearsay evidence, how are you going to consider that evidence in determining that charge?
It will still border. Okay. First of all, I think you look at the circumstances under which you had the evidence.
I can simplify it further. Is it admissible?
In my case, I don't think it's admissible.
You know, I want you to tell me things that, not things that you think, but things that you know.
Yes, my lady. It is not admissible because if you had, for example, if you're talking about a murder case, I had somebody being killed. Did you witness? Because I think you're looking at the weight of that kind of evidence.
All right. You are near there in terms of saying that it is not admissible, although you haven't quite told us that. So I want to give you a scenario. There is a person who is at the point of death.
Yes. And
he has been stabbed. And he says, God forbid, I was stabbed by Adelaide. Yeah?
Yes.
So in terms of what we've talked about here as evidence, the person died. And the witness is saying, I heard the deceased say, I was stabbed by Adelaide. What is the value of that evidence in that trial?
I think now that will carry some weight, because if the victim, or rather the deceased, was able to identify, and by calling out that name, that I think that will hold a higher threshold. I would take it in. But then again, not only on its own, but also other circumstances, because you'd have to check up, for example, if after all you've mentioned my name, for example, in terms of when the investigations have been done, was I actually at the scene of crime? Can I be connected to that scene of crime? So I think on its own, no, but when you put them all together,
so if
yes.
The only evidence that is there in that criminal trial is that evidence that the deceased person mentioned the person who stabbed him, is that sufficient for purposes of a conviction?
My answer still would be no.
I think you'd need to check on that. And you know what these, what we are talking about in terms of how are they classified? How is it classified? Is the evidence of a dying person who subsequently passes on, having said who stabbed him or who caused the injury that eventually led to his death? Have you heard of a dying declaration?
Yes.
Yes. After this, please check whether the dying declaration is admissible, and whether it is, okay, you've said it's admissible, whether it is sufficient for purposes of a conviction without any other evidence. Okay. Thank you.
Thank you, my lady.
Thank you, Chair. Good afternoon once more.
Good afternoon, Commissioner.
I just want to